Right. Well, I have 7 o'clock, so we'll go ahead and get started here. And welcome to this evening's Q&A talks. First off, I wanted to thank everyone who came out this last week for the 5th annual Southeast Kansas Pride. If you missed any of our workshops or discussions, you can watch them here on our Facebook page, or you can go over to our YouTube channel and check out all of our virtual Pride events on our YouTube page, as well as our last year's Pride events as well. So be sure to subscribe to our YouTube page so you won't miss any of our virtual content. You can even see our Q&A Talk Pride edition that took place last Wednesday, where we had a conversation with Tegan Cardwell about coming out. But tonight's Q&A Talk is in partnership with the Independence Public Library and is made possible by a grant from the American Library Association. The library's Transform Community Grant is an initiative to help support small and rural libraries across the country. And yes, libraries truly do transform communities. And our library here in Independence is doing just that through this partnership. This month, we have the senior staff attorney, Josh, from the ACLU of Kansas, with us to talk about the rights of LGBTQIA students have at school. Josh is a senior staff writer at the ACLU of Kansas. Before joining the ACLU, Josh was in private practice, litigating and trying cases on behalf of individuals with employment and civil rights claims. He spent 8 years with his former firm, first starting as an associate and ending his time there as a partner. His cases routinely included allegations against major corporations, as well as state and local governments, and Josh routinely appeared in state and federal courts as well as before various administrative agencies. Josh went to law school at Washington University in St. Louis. While there, he worked as a research assistant focusing on death penalty cases and rights of habeas corpus. He was a judicial intern at both the St. Louis County Circuit Court as well as the Federal District Court of the Eastern District of Missouri. Josh also received the Don Summers Award in professional responsibility for obtaining the highest grade in his legal ethics class. He received his undergraduate degree in music performance from the Conservatory of Music at Lynn University, studying the trumpet under Professor Mark Reese. When Josh joined the ACLU of Kansas, he also returned home. He is originally from Overland Park and now resides in the Kansas City area with his partner and their 3 children. Please welcome Josh.
Thank you, Brandon. I appreciate it. And it's very, very nice to be here. Thank you all for attending and for paying attention. I'm happy to be able to present on this issue, on these issues, really. And so you should, as you can see the presentation here, we're talking about rights in schools for LGBTQ folks. And it was fun for me and kind of unusual in some ways for a civil rights lawyer in Kansas to be able to put this together and sort of feel like there's actually good news to share. The reality is there actually are quite a few rights, and things have changed even in my legal career, as short as it is. And so I hope to kind of walk through some of this today with you and share some of this. And, please feel free to ask questions either in the chat. I think we'll be taking those up later, then there'll be the Q&A later also. So let's kind of dive right in here. First, very simply, freedom from discrimination is a right that we all have and that we have in the educational setting in particular. And the big federal piece of legislation, the big law that sort of guarantees these rights is Title IX of the Education and Amendments Act of 1972. And you probably have heard about this statute and Title IX in many different contexts and in many different ways, but it is sort of the bedrock legislative protection from discrimination in the educational setting. And Title IX applies to essentially all institutions of education that receive federal funding, which for the most part really means all educational institutions. It would be an extraordinary exception if Title IX didn't apply to your school or your child's school. And so really this is the law of the land for education. You see here the first thing that I have up, Title IX applies to more than simply sex discrimination, but it really does cover and apply to sex discrimination. This is language from the statute itself. no one shall be excluded from participation or denied the benefits of any educational program on the basis of sex. That's the original language from Title IX. And what we have seen over the past few years is really reading that language and using that language to provide protections and provide rights for LGBTQ folk. And so as it stands now, really Title IX prohibits discrimination, not on the basis of sex, which really means also includes because of gender identity or because of sexual orientation. And so you see here on the basis of sex, that language in the statute really ends up doing quite a bit of work for us. This is, again, relatively new territory for the law that is being read this way. If there was a great victory, many of you maybe have followed it, but in last summer, 2020, the Supreme Court handed down its decision in Bostock versus Clayton County. That decision was a decision not on Title IX, actually, on Title VII of the Civil Rights Act of 1964, which that law doesn't address educational institutions in the way that Title IX does. It actually deals with employment discrimination and the rights of people in employment to be free from discrimination. But the language in that law, the law that the Bostock court was addressing, is very similar to the language in Title IX. And the result of the Bostock decision has been the sort of cascading effect of rights, really, moving forward. And so you can see here on the slide, I mean, so the central holding, the big thing that Bostock did, the big extraordinary thing that Bostock did was find that discrimination because of a person's sexual orientation or gender identity is in fact discrimination because of sex. And so it's a landmark case. It's a watershed case. It's truly was an amazing kind of moment in Supreme Court jurisprudence. And the result for our purposes, the result for students and for people in educational institutions and under Title IX is that now the Department of Education formally interpreted Title IX in this exact same way. And so that on the basis of sex language from Title IX, the Department of Education reads in the same way that the Supreme Court read Title VII. And so it's an extraordinary accomplishment in many ways for rights advocacy groups and for the rights of all of us, really, generally. That's Bostock. That's formally the rights now under Title IX. I want to talk about sort of specifically what that might mean in the context of students and what that means in the context of the kinds of behaviors that are not tolerated or are now clearly unlawful. First, it's important to sort of note, I'll make this distinction between sort of what we might call sort of traditional or common discrimination versus harassment or sexual harassment. So I think harassment ends up becoming a bigger problem in many ways. And so I want to kind of address that more thoroughly. But bear in mind that Title IX, it's not just about harassment. Actually, discrimination in its more sort of traditional sense, in other words, like denying people access to activities or denying people access to classrooms, or one victory that our office had here recently was for a young woman who was then in 8th grade, who was kicked off of a school bus for saying that she was a lesbian. And it really was that simple. And the school bus driver was accusing her of being inappropriate and saying that the driver had young children up in front, and that wasn't an appropriate thing for young children to hear. What was particularly galling was that there was actually video from the school bus in which lots of sort of a raucous, it was a school bus and young children were misbehaving in many ways. And children were throwing around curse words, using the F word, saying far more offensive things and saying actually offensive things. And it turns out that our client, the student, who literally just voiced that she was a lesbian and was the only one to get in trouble, not anybody else in on the bus. So her and her family, with the help of our affiliate, brought a Title IX complaint and ultimately was successful, and there was found to be a violation. So it's obviously a nice story to share in many ways about people being able to vindicate their rights, but it also is an example of, in her case, just the denial of access to the bus, being kicked off the bus, the reprimand itself is sort of a more traditional kind of a more one event kind of discrimination. So Title IX applies to instances like that. That was a pretty extreme case and a pretty clear violation of Title IX. And I think probably what happens more regularly, or perhaps is more, in many ways, maybe more dangerous, is sort of an ongoing pattern of harassment or an ongoing pattern of exclusion. And Title IX applies to that. So it isn't just the denial of the bus or the denial of some access or something like that. It is actually applies to harassment. And I have some examples here. Obviously, there are very egregious versions of this, right? Sexual advances, requests for sexual favors, touching, jokes, gestures. I mean, there's some sort of obvious, very egregious ones. But I think the thing to sort of note is that it's possible that a course of bullying could itself could violate Title IX. And it's worth noting that it's not just from staff. So like in our case, it was a bus driver and the school administration that was sort of the perpetrators of the discrimination, right? But Title IX could potentially apply to student or peer harassment. And so that is something worth bearing in mind. Harassment, I have some language here. Harassment sometimes gets defined by the courts in different ways. There's different sort of formulations for how courts talk about what is harassment. And bear in mind that I think the important thing to understand is that Title IX prohibits discrimination because of sex, which we now understand and know means discrimination because of sexual orientation or gender identity. But it's the discrimination itself that is unlawful. And so harassment rises to that level when it reaches some severity that actually courts would then acknowledge as discriminatory. And so it creates this sort of murky territory where, there might be awful things that are said or awful things that happen that maybe don't quite, or a court wouldn't quite read as harassment. But that's sort of, I think the thing to understand there is that it's sort of a problem for lawyers, right? I encourage you, we'll talk about sort of things to do here in a little bit, but I encourage you to sort of talk to your children, talk to the students. I mean, if you find out this kind of harassment is happening, if someone is being bullied because of their sexual orientation, because of their gender identity, to complain, to talk to administrators about it, and whether or not it formally meets these sort of legal definitions of harassment is not really a concern worth having at the moment. That instead, raising the issue at the first instance is probably the wise thing to do, and hopefully your school district listens. Hopefully they would be able to take some action or put a stop to it. Many school districts have anti-bullying policies on their own that might apply in a separate way. And so it's worth pursuing, worth advocating for yourself or for your children. And it's also important to do because for Title IX liability to attach, in other words, for a school to have violated Title IX, especially in the harassment context and especially sort of in the peer-to-peer or student-to-student harassment context, the school district has to have known or reasonably should have known that there was the violation. So it's often compared in legal circles to the dog bite rule. So people, if a person has a dog who is violent and who bites, the first bite, there's no liability. But the second bite, when the owner knew something could happen, is when there maybe is a case. And it's an analogy to here. So it's the first time there's some problem, the first time there's a harassment or a harassing issue, maybe the school district isn't liable, but certainly the second time it is. And so again, this is another reason why it's important to raise these issues, to try to address them as soon as you can. And so here, very simply, what to do, like I said, I encourage you to raise these issues with administrators, with your students, teachers, and then to make administrators aware, to complain, to really be noisy about these problems if they are happening. And then finally, there's the formal Title IX process. And I kind of want to spend a little bit of just time touching on that. It is supposed to be sort of user-friendly, the Title IX process, the complaint process. It shouldn't really be a difficult thing to navigate. You're not really supposed to need a lawyer to be able to file and pursue a Title IX complaint. Unfortunately, that's not really always the case, that it sometimes requires some digging, requires some research into school policies, research into Title IX itself. But there are a couple of things that are working in your favor. First, every school that is subject to Title IX is supposed to have a Title IX coordinator. So it's supposed to be a person designated to handle Title IX issues and complaints. And that person should be somebody you could find relatively easily. It really should be on a school's website, but even if it's not, it should be somebody that the school can tell you who that person is. And so that person is obviously a resource and somebody to go to. I shouldn't say obviously, but that person is supposed to be a resource and somebody to go to if you or your children are experiencing harassment or bullying or discrimination as a result of their sexual orientation or gender identity. So that's number one. The school is supposed to have a Title IX coordinator. The school is also supposed to publish its Title IX processes. It's supposed to be available to students and to parents, what your rights are, what the process under Title IX is. And in short, Title IX requires schools to promptly investigate and resolve complaints of sexual discrimination, sex discrimination, including sexual orientation discrimination and discrimination because of gender identity. And so once you make the formal complaint, the school is supposed to do something about it. They are supposed to look into it, investigate the facts, talk to the appropriate people, and also then take action. So if it turns out that there is a violation, the school is supposed to take a remedial action and make sure it doesn't happen again. That can be a tricky thing. Sometimes it isn't exactly clear what should happen, but there should be a reaction on the part of those in power, of the school administration, to do something to prevent the discrimination from happening again. It can often take the form of training, which is sometimes not so satisfying. People just get trained, but that can be an important component. And I think more practically, if there is a person or persons, especially if those people are teachers or staff who are the discriminators, it might be appropriate for the school to take disciplinary action, or certainly to create an environment where the student is no longer interacting with that person, or there are protections in place so that the student is no longer the subject of discrimination, of the harassment. So that's sort of that's the Title IX process, the Title IX rights, and the big good news, the big win, really since in the last year, is that Title IX does now apply to sexual orientation, gender identity, and students who are discriminated against because of those factors have the complaint process and have Title IX available to them to remedy the situation. So that's Title IX. That's really the big collection and bucket of rights that people in schools have in this regard. I wanted to touch briefly about student organizations, and we, the ACLU, have received some complaints about this in the past and here recently. This is really old news. I mean, it has been very clear for a long time now that the schools really can't prohibit students from organizing. The big one is, of course, Gay Straight Alliances. This is not cutting edge legal work in some of the ways that that the Title IX stuff we just talked about is. It has been settled for quite a while that students have a right to form gay-straight alliances, to organize in this way. And it's really, it's because the First Amendment applies. This isn't an issue of, changing social norms. This is an issue of developing, new understandings of discrimination. It's really just bedrock First Amendment principles that students have a right to associate and to express themselves. And that takes the form of, if it takes the form of a gay-straight alliance or any other kind of organization like this, then that's all right. Schools really can't prohibit this kind of organization or this kind of activity, and doing so is problematic. I have a list sort of what they cannot, right? I mean, so generally speaking, singling out gay-straight alliances for parental consent is not necessarily okay. Denying students the right to form gay-straight alliances in the first place is most likely a violation of the law. You will hear, and again, it's surprising, we still hear this, that, the school is concerned about the controversy surrounding the issue, or how the organization is controversial, and we support all of our students, but this issue is controversial. We don't want students engaging with this. And it's just not an excuse. It just isn't a reason that schools can use to prohibit this kind of organization. There are actually cases about schools that require clubs to tone down, be less gay. I mean, like, all of this stuff is not okay. Students have the right to express themselves in this way. And then, really with this last point here, deny gay-straight alliances access to material or resources that other non-curriculum organizations have access to. Not okay. And that really gets to the crux of all of this, which is that, it is conceivable. There is sort of a thought experiment you could run about, well, what if a school just prohibited all clubs, all organizations? Would that be okay? And I don't actually know the answer to that question, but in reality, that's not what happens. Schools allow clubs, allow students to organize around other things. So if the chess club gets to use the billboard, so does the Gay-Straight Alliance, and they can't treat these kinds of organizations, student organizations, differently than they do other student organizations. We'll talk about sports in a second. It would be a mistake to when I say non-curriculum groups, it's these kinds of things, these sort of extracurricular activities. It's not quite the same as sports. We'll talk about that in a second. Anyway, so again, good news there, and it really settled law. I mean, so if your child or your family member or you are being told that you can't form a gay-straight alliance, you're not allowed to do certain things, it's a problem, and it's been a problem for a long time. So, all right, that's student organizations. These next sort of issues that we'll go through really deal more with transgender rights specifically. And so there's been a lot of litigation, a lot of cases. This has been the last 5 years or so, has been a real hot button issue. I think there are some sort of unsettled questions here. There are some issues that there may not be, I can't point to a specific case that says, yes, this is discriminatory, but in general, that stuff we talked about at the very beginning, the Bostock decision in 2020 really went a long ways to making clear that transgender rights are protected, that discrimination against transgender students is discrimination because of sex, and therefore a violation of Title IX. So this is, in general, another positive development of the law. So first, access to restrooms and locker rooms. It's always the bathroom, right? Isn't it? It's just like, it's people are obsessed about this, and it doesn't make sense. But a couple of things to sort of note here. So first, there is no Kansas or federal law that requires a school district to make students use the bathroom that corresponds to their gender assigned at birth. It just simply isn't a requirement. So no school district can say, oh, we have to do this for X, Y, and Z reason. And in fact, there have been some challenges from straight parents and cisgendered folks saying that allowing transgender students to use the bathroom that matches their identity is discrimination of some other kind, discrimination against the cisgender folks, and those have failed unanimously, roundly failed. That's not a valid argument. So that does, though, raise the question, like, do schools have to allow transgender folks to use the restrooms or locker rooms that correspond to their gender identity? And I think the short answer is probably yes. At this point, probably yes. I'm not aware of sort of a decisive case that says that is the law. But given the language in the Bostock decision, given how the Department of Education is reading Title IX at this point, if I were advising school districts, no school district ever asked me my opinion, but if I were advising school districts, I mean, it seems very clear that prohibiting transgender students from using the bathroom that corresponds to their gender identity is discrimination under Title IX. I have a little bit of facts here you've seen. I mean, so here's an example. Elections matter. Things change depending on who's in power. And so you can see, like in 2015, 2016, it seems like a long time ago in some ways at this point, the Department of Education was reading the Title IX regulations to require schools to allow people to use the bathroom that matches their gender identity. That changed in 2017 and 2018 under the new administration. Those regulations were rescinded. The Department of Education stopped enforcing those regulations. But of course, we are now in yet another administration which has started reinforcing those regulations again. And we also now have the Supreme Court decision in Bostock. I mean, so it probably would, even if we were to get a new administration, in the future that decided they didn't want to read or didn't want to allow students to use the right bathroom again, probably now there's much stronger arguments. It's a much better world for people to be able to argue that's not allowed. I put this case up here. This was a sort of a victory of the ACLU, both the national office and then the Virginia affiliate, this Grimm versus Gloucester. Actually, I don't know if I say that correct, but Gloucester County School Board. It went all the way up to the Supreme Court, all the way back down to the trial court, and then up to the Intermediate Court of Appeals again in the Fourth Circuit. Essentially, this was the question. Does Title IX require schools to allow students to use the right bathroom? And it's not quite as clean as yes, but it's a big victory, and it seems pretty clear that the answer is yes. And you can see here, it was just literally a few weeks ago that the Supreme Court denied the petition for certiorari. So, in other words, this Fourth Circuit decision, which held that Title IX means what it says, and people have to be able to use the right bathrooms. The school district tried one more time to take that up to the Supreme Court. The Supreme Court said, no, we're not hearing that case. So basically, it looks like that's the law. Anyway, so that's bathrooms, locker rooms. Again, it's not quite as clear of when, this is the best site I can give you, but it's good news. And this really should be good with the way going forward. Name and pronoun usage is another issue. I think that's probably very important. This is maybe the least clear and not as established area. So Kansas law itself requires children, when they are first enrolled, to provide proof of identity. Really, that probably means a birth certificate. There are other ways, but in general, that means birth certificates. So that's the case. I mean, if you start going to school in Kansas, you have to turn over your birth certificate. But it's important to note that nothing about that requirement requires schools to then refer to children by the name on that birth certificate, or treat children by the sex that's indicated on the birth certificate. I mean, it's literally just it's a proof of identity requirement. It's not anything more than that. So sometimes you see people citing this as like a reason why schools have to do, or why we have to refer to people a certain way. It's just not what the law says. And so then we get to this, well, what about if they do? What if a school does insist on calling someone by the name that was given to them at birth, or by referring to them with the pronouns, or by their sex assigned at birth. And the short answer is it may violate Title IX. It's not quite as clear as that they have to, but this sort of takes us back to that definition of harassment at the beginning of the slideshow here. So if it were to become this pronounced and discriminatory practice, I think there's a good argument. I think it's probably the case that Title IX is implicated and that wouldn't be permissible. And again, if I were telling a school district what it should do, that would be what I would tell them. There's a very good argument that Title IX applies. And so, make some noise, like if this is something that teachers are requiring or insisting on doing, or school districts or school administrators are insisting on doing, make some noise. And there might be some success there. But it isn't quite as clear as it's just prohibited. The other thing that it does implicate is FERPA, which is the Family Educational Rights and Privacy Act. So this law, it's funny that it's in here. It's really not like a civil rights issue in many ways. FERPA is about student privacy, about the disclosure of student names and all of that. But what is interesting is that potentially a student who is transitioning, or even the fact that someone is transgender, I mean, a school outing its own students by using the wrong name, using the wrong pronouns, is potentially a violation of FERPA. And it potentially is, sharing private information about students that the law prohibits the school from sharing. That's sort of a novel theory. I don't know of any case that has tested that, but it is something that might make administrators nervous and should make administrators nervous. So that's one other issue. Finally, athletics. This, of course, was the big fight over the last legislative session. Many of you may have followed the progression of SB 55, which I don't have to tell you. I mean, it's just horribly demoralizing, dangerous, and it's a shame that it was a fight that had to happen. I'm not the first person to say it, but it's beyond being discriminatory. It's also just a solution without a problem. I mean, this just isn't something we should have been talking about at all. But the good news is that in Kansas, of all places, it didn't pass. So Governor Kelly's veto wasn't overridden. Really came down to about one vote. And so it's not really an issue we have to deal with. And I think it's interesting and I guess actually maybe for those who weren't as tuned into it, I mean, so SB 55, it's the anti-trans bill. It would have prohibited transgender women from participating in sports at any educational level, including at the college level. And so that isn't the law. That isn't something that Kansas is requiring at this point. There's also very strong arguments. The ACLU promised to sue had it become law. And so there are very serious questions about whether that's even constitutional or even permissible. Probably it's not. And so this isn't an issue. Really, students should be allowed to participate in the sport that corresponds to their gender identity. And it's really just that simple. That's sort of what my prepared remarks are. I think I might have come in a little bit under time here, Brandon. But I wanted to put this last slide up as well. So we at the ACLU are here for you. Our affiliate and our legal department in particular has identified this issue area as a priority. And we've been able to do some good work already over the summer in this area. And so I just wanted to share that we are a resource for you. We talked a lot about all the things that school districts can't do, all the rights that students have. Those are all sort of meaningless unless you can enforce them. And, the ACLU is prepared to enforce those rights. And so, here's our contact information, as well as our legal intake email addresses. And so if you or your child are experiencing discrimination in this way or feel like your rights have been violated, I encourage you to contact us.
Thank you so much for a very informative presentation. For those of you watching on Facebook, if you could, there's an exit survey if you don't mind taking at your convenience, but we're gonna switch over to Zoom now. Here in a few seconds, I'll post the links in the comments. So if you have any questions for our presenter tonight, click on the link that I put in the comments here in a second, and we'll wait for about 5 minutes for you to log on to Zoom. And while I'm posting that in the comments, I do have one quick question for you, Josh. So back to the GSAs. What do you do if an administrator doesn't blatantly say that it's not approved, but continues to kind of kick the can down the road, or go talk to the school board, or passes it on and makes it more challenging?
Yeah, I mean, that's a good question. And it's sort of, I mean, it's very clear you have the right to do this. There's sort of become factual differences in any case. And so whether the school board is actually, or whether the school is actually denying the formation of it or not, or whether there truly is some sort of just delay, it would really depend. It's hard to like sort of give advice about a hypothetical like that. But in general, I mean, again, make some noise and make it clear that you have this right and the delay is not acceptable. And then, whether there was some sort of claim or legal action that could then be brought would be a different question and would have to be evaluated. But it's sort of a non-answer, I suppose. But in general, they shouldn't be treated, these organizations shouldn't be treated any differently than any other organization. So if it looks like, they can approve every other club in a matter of days, but the GSA is taking months, and that's an issue. That's a problem. I encourage you to get in touch with us if that's the case. I think you're muted there.
Yep, it's been a long day. I'm sorry about that. So yeah, we will give you about 5 minutes to log on to Zoom to continue this Q&A session. We'll go ahead and close the Zoom room if nobody logs in by a quarter till. Thank you once again, Josh, for coming and or virtually joining us tonight for this presentation. And thank you all for watching it on Facebook. So like I said, we'll be here till about 7:45.